What's up, everybody? Welcome back into an episode of The Lawyer You Know. And it was a huge day today in the Karen Reed trial. We had the continued testimony of Dr. Russell, who I thought handled Hank Brennan during his cross-examination rather than the other way around. But then we had Sergeant Barros, who blew potentially the biggest hole in the Commonwealth's case to date. And that's saying something because we've had Proctor text. We've had all sorts of things come out in this trial. So to say that he blew the biggest hole was huge, but then we got to see some good lawyering from both Hank Brennan and Alan Jackson. We'll talk about what the end result of all of that might be to the jury, and we will discuss the motion for mistrial that was an explosion in the middle of the day today, whether or not the judge made the right call, and if it is going to be a major appellate issue if Karen Reed is convicted. So make sure you guys hit that like button. Let's get to it. So much happened today. So much, right? And there's just so much to talk about. We're going to work our way through it methodically, starting with Dr. Russell, because a lot happened during her cross and redirect that I thought was incredibly important. I thought her direct went well. I thought she did a great job. I thought she had a great resume. I thought that she explained how this was very likely a dog bite. And at the end of direct, I was like, it feels like if this was a criminal trial and the dog was the perp, that maybe this would be enough to prove beyond a reasonable doubt this was a dog bite. Maybe not, right? But we get to see in cross what Hank Brennan can do to Dr. Russell. And the first part of his cross, I thought, oh, he found something here that maybe he can attach to some other things that he's built on. So let's listen to how he kind of got out some things that happened overnight between Alessi and Dr. Russell. And we'll talk about whether or not they were appropriate here. First, she impeaches Dr. Russell about the fact that in a prior hearing, right, not trial, it was Alessi, she said, helped her with the organization of her report, not some other lawyer. So he impeached her with that to start, but then he gets to this.
By the way, between last night and today, did you get any advice from anybody suggesting you should ask for a transcript when I asked you a question? Did that advice come your way?
That's my general advice from previous times.
Well, did you have any advice last night about that?
Yes.
Who told you last night that you should always ask for a transcript when I'm asking you questions?
Well, I think it was just Mr. Alessi.
So did you and Mr. Alessi, you know there's a sequestration order, don't you?
Yes.
A sequestration order that you're not supposed to discuss the case at all with anybody?
Well, we didn't discuss specifics.
Do you know that the sequestration order mandates that you not discuss anything about the case from when you start your testimony until you end your testimony? You know that, right?
I understand that there is a sequestration order.
Do you understand the sequestration?
They both stutter over sequestration order, but Brennan is right here. Alessi should not be talking to a witness while they're on the stand. It could be considered coaching. It could be a problem. And he pretty much should just move on here pretty quickly to the next point because he's already gotten that out and he could potentially argue now. Not only were they trying to tell Miss Dever what they wanted to say and threatening her with perjury, they're telling witnesses to ask for transcripts and coaching witnesses in the middle of their testimony. He can make those arguments, but he just goes too far with her, which we're about to watch, where he just loses it all. Anything that he was building up here just falls completely flat. And as far as what Alessi did, it is not anything that is material. It is not anything that's going to garner him a significant sanction. It is going to be literally nothing the judge is going to do. At the very worst, she would admonish Alessi and say, please don't talk to your witnesses when they're off the stand. They spoke of nothing of materiality, nothing of substance. He told her to ask for a transcript if not sure. And frankly, if I was Alessi, I would argue, Judge, I did tell my witness that because Hank Brennan was not being truthful when he said he was reading stuff from a transcript. And this witness was giving him the benefit of the doubt because he's a lawyer and a licensed member of the bar, when in fact, he even admitted the things he was saying were not in the transcript or on the report or whatever he said he was reading from. So because of that, I felt compelled to tell her, don't just trust Hank Brennan, ask for the transcript. That's probably how I would respond if I was Alessi and this really did come to a head, because that was happening yesterday, in fairness to this witness. She was kind of just trusting Hank Brennan, and then he admitted, oh yeah, this was on the report or the transcript. This was not. So I did think Alessi would have had a response.
Order mandates that you're not supposed to speak to people, including the attorneys, about this case overnight. Did you understand that?
There were no specifics discussed.
But did you understand that you weren't supposed to, is what I'm asking? Did you know that's a violation of the sequestration
No, I did
order
not.
to speak to the attorneys overnight?
I did not know that that particular conversation would be a violation.
So did you meet with Attorney Alessi last night?
No.
How was it that you had a conversation with him?
Actually, it might have been in the vehicle.
You drove together?
Yes.
So did you commute to and from court together with Attorney Alessi?
Well, there's a driver.
Okay, who else is in the car?
Here's what I'll say. That may sound nefarious to some, or nefarious to some jurors, but everybody basically is out of town. All of these experts are from out of town. Half these lawyers are from out of town. So it's really not that weird. If you're going to get an Uber or a driver of some sort, there was some cringe here, right? They rode together, she says, in the limo. Seems a little weird. Like maybe the jury's like, is Karen Reed trying to be famous out of all this? They hear a lot of people talking about it being on TV and on the news. So maybe, again, Alessi is getting some side eyes from the jury, Brennan is getting some side eye from the jury, which is what he's trying to do with this witness, thinking, oh, is there something weird going on here? And if he would have stopped before the last question, maybe this would have come off better.
Car when you left court yesterday?
The driver.
Were you-
No, I wasn't with him yesterday. No, not in the car yesterday. No.
Well, you just said that you spoke to Attorney Alessi yesterday. And
And there's times where both the lawyers are going to talk to witnesses. You shouldn't. You should be really careful about what you say, but it's going to happen through a long trial like this.
I figure out, when was it that you were having conversations with Mr. Alessi relative to the sequestration order that you're under?
This morning, riding to court
Okay, so you and Attorney Alessi drove to court?
with the limo driver. Yes,
Who was in the limo with you and Attorney Alessi on the way to court today?
that was just us.
Just you two?
Surprised Brennan didn't say, oh, the limo, excuse me.
What else did you both talk about other than that you should ask for a transcript every time I ask you a question?
That's what we talked about specific to this case.
Was it a long conversation?
No, not at all.
The entire ride here, there must be more you spoke about other than just the sequestration order.
We did. We spoke about Boston, how I love Boston area. We spoke about New York. We spoke about other things. And in fact, I have to say that even on the ride home, back to the hotel yesterday with others in the car, nobody spoke about the case.
But I'm talking about this morning when you did speak about the case. What else? Not about the Red Sox or the weather. What else did you talk to Attorney Alessi about this morning other than you should ask for a transcript every time I ask you a question
We talked about what I did last night.
about this case?
It's funny to see everybody say, it's not a limo, it's an SUV. Oh, shocker, the millionaire lawyer has a limo. I'm not saying there's anything wrong with any of it, right? And I'm not saying it is a limo. What I'm saying is the jury heard her say she and the lawyer rode a limo together to court. And I will tell you, with my experience with normal, everyday people who sit on jurors, sometimes they don't like that kind of stuff. And I think if Brennan would have just moved on, this could have been something that he could have used later as making another point, right? But he blows it. He blows it in the way that he keeps going with Dr. Russell, who does not strike you as, and this is another person who, my guess is she's made a decent living throughout her life. And Hank Brennan acts like she needs to, lie or take pictures of herself in this hearing in order to make more money. And just to me, I think that falls a little flat.
Case?
No,
I'm sorry, but I'm asking about this case.
that was it.
I want to know what all the discussions were between you and this attorney today or last night about this case.
Just that I should ask for a transcript.
Well, there must have been some concept. There must have been some context. He didn't just turn to you talking about the weather and say, hey, you should ask for a transcript. You must have been talking about something.
He also generally, not today, but generally says, be honest. Always be honest.
Fantastic. But this morning about your testimony, what did he tell you? Did he tell you this morning you should be honest?
Not this morning.
Okay. Does anybody need to remind you to be honest when you testify?
No.
Okay. What else did he tell? How did it come up? Hey, by the way, ask for transcripts.
I don't even know how it came up. I didn't put much significance to it.
Well,
So now is when Brennan should have just moved on.
it was just moments ago it happened because you just got to court. You can't remember the context of the sage advice of Attorney Alessi?
No.
Do you have any memory issues?
No.
And look at her face. I mean, look at her face. She's just so disappointed. She's like, Mr. Brennan, you didn't have to do that. I understand you've got a job to do. I understand you're doing your best and you're fighting hard for your client, but you really didn't have to do that. And she's like, legitimately shocked. She's like, by the way, Dr. Russell, just want to tell you, you're dipping your toe in the forensic testifying doctor waters. It is not as it may seem. Everybody is not respectful. Everybody is not ethical. Everybody is not going to treat you the way you want to be treated or the way you think you should be treated. So be ready for lawyers to be jerks. It happens. And somebody said that reports inside the courtroom were that the jury did not like how he crossed her. And to me, after, impeaching her before you said Alessi, after saying Alessi's coaching you up, some things that he could have argued, he got a couple of points across. Again, this is just where it ended for me to say, like, ugh, it's going to be tough now, man, because everybody's probably looking at you like, that was not a good move. That was not a good move at all.
May I approach?
Yes.
And then he did this over and over again. Since Mr. Alessi told me or told you want to see the transcript, I guess we'll go. Or because Mr. Alessi said so, or I guess I'll approach because you asked, even though I didn't need to. And Mr. Alessi's sage advice, and he makes all these like comments that are just unbecoming.
Since you've asked for the transcript, I have it for you. Dr. Russell, this is June 21st, 2024. I had asked you whether you expressed that you couldn't say with 100% certainty you agree with my answer. So there's no need to try to refresh your memory, but I'm going to show it to you because you asked.
None of that is a question, but Alessi didn't object. And so there's a couple overarching themes I thought were problematic with Hank Brennan's cross. One of them is this 100% certainty. As if any witness that's an expert that was not there and seeing it can say anything with 100% certainty. That's just not going to happen. And number two, she doesn't have to prove anything. They don't have a burden of proof. They don't have to prove anything with 100% certainty, 90% certainty, beyond a reasonable doubt, by a preponderance of the evidence, probable cause. They don't have to prove anything by any standard. And yet, by doing that, you're basically burden shifting in a way that the jurors hopefully will understand is not how this works.
Take a look at line 16. Is that now consistent with the questions I asked you and the answer that you gave, that you were less than, couldn't be 100% certain?
That looks consistent.
You want more time with the transcript?
No.
Has anybody else talked to you about your testimony today overnight, Dr. Russell?
No.
When you testified last year, same transcript that we just looked at, do you remember when you gave your opinion to a reasonable degree of medical certainty, you said that you thought the wounds were from an animal, possibly a large dog?
On that same date?
Yes.
May I see the
Of
transcript?
course. Pursuant to Attorney Alessi's advice, let me approach.
Objection, Your Honor.
I'm going to strike that, disregard that.
I mean, that is just, and Jackson gets pissed about it later. And I've had to do this in trials before when another lawyer will do something over and over again. It's like, Judge, you have to tell him to stop. Like, you have to tell him to stop, especially when I can't make speaking objections. And sometimes the unethical lawyer is the one that's going to push the rules. And it's like, he's doing this in front of the jury. And I can't even say objection speculation, Judge. Like, this is messed up. And I've seen cases where lawyers go too far with their demeanor and the way they act and what they say in trial, especially prosecutors, because criminal defense lawyers, like, you can really push the bar. And if it's a not guilty verdict, it's not going to get that overturned, obviously. So you want to stretch sometimes. You take some chances. As a prosecutor, you've got to be way more careful because appellate courts usually care about criminal defendants' rights. And if they find that you stepped on those rights or you went too far or you were too sarcastic or you said things in the jury, knowing the jury should not have heard them or seen them, that can be a much bigger problem than if you're a criminal defense attorney, which is what Brennan is used to. So again, he, pursuant to Mr. Alessi's advice, he approaches, and they go and they talk through whether it's a large animal or a large dog or possibly 100% certainty. Is it the nails? Is it the tooth? What mark did this tooth make? What tooth made that mark? Which is just so very clearly not how it works, but he's trying to poke holes. And I think it's pretty funny because if I'm Alessi and we know Welcher's coming back on the stand eventually, I'll say, what shard of glass or plastic made this mark on John O'Keefe's arm? What shard of glass or plastic made this mark on John O'Keefe's arm? Which very obviously Welcher would not be able to do because nobody can really say that. Like, nobody can say that. But that's what he decided to go with here. Brennan starts to argue that John O'Keefe, and I actually thought this was a good point. I'm trying to, highlight some of the good points as well, because overall, I thought this cross was wholly and completely ineffective on Dr. Russell. I thought her demeanor and how she handled everything was pretty great. He had some stuff he could work with, but he would immediately follow it up, kind of, looking like a jerk. I don't think the jury would like him during this cross. But he did make a good point, I think, that why were there no lower jaw bites, right? Like, we're thinking it's a lever and it would bite like this. And if that was true, wouldn't the underbite be here? She said, well, some of these other marks could be the bottom jaw, but you're right. We sometimes would see that, but there are situations where they just bite and just the top hits and not the bottom. And I thought that was a good job by Brennan to at least point that out. I also thought, so this is just another overarching theme to his cross. I thought it was way, way, way too long. Way too much talk about dog bites. And you may say, Peter, she's a dog bite expert. What else is he supposed to ask her about? Well, frankly, he took so much time talking about these dog bites and whether or not she's 100% sure, fairly certain, very certain, reasonable degree of medical certainty, that if I'm the jury, this seems like a dog bite trial. I would have rather get her up and out as quick as possible, get her off the stand. She's too good of a witness, like Alessi did with Wolf. And like Lally, frankly, I think if I remember correctly, Lally did not ask her a ton of questions. You know what he did focus on? The lack of dog DNA, which Lally brought in their case in chief. And the way he set that up, I think, was very effective in minimizing Dr. Russell's testimony. Now, her testimony has definitely gotten better from trial 1 to trial 2, and Brennan talks about those inconsistencies, and, they talk a lot about that. We may hear some of it in some of these clips. But I thought he had her up there for way too long. And now looking back, knowing he was going to be allowed to get into the dog DNA, I would have been like, there's no dog DNA, right? There's no underbite, right? You don't know which tooth made which mark. There's no puncture, right? All right, that's it. Sit down. That's what I would have done. A much, much quicker cross. To have her up there so long, to me, was so much better for the defense. We're going to jump ahead here a little bit.
Accurate because there's no scale in the picture.
Why did you go through the process of measuring them if you're now saying that it's inaccurate after I asked you if you memorialized it? Why would you even do it if you're now saying it was inaccurate?
It was an approximate measurement in my mind.
In your mind?
Yeah.
Okay, but you never put it on a piece of paper or report, notes?
That's correct.
Why would you even go through the process if you're looking at it and your explanation is, it's only a photo, I wouldn't be able to tell? Why would you even try to?
I think probably everybody in this room has already done the same thing.
And if anybody in this room did the same thing, it would be quite...
She's right. Everybody in the room is trying to figure out what those are, and they're going to use their common sense, and I think she was very helpful with that.
Very obvious, doctor, that the gaps between 1, 2, and 5 are dramatically different from each other, aren't they?
They are. However, I'm not saying the same exact teeth caused those marks.
When you testified yesterday, you used the term differential diagnosis. I want to ask you a lot of questions about differential diagnosis. Do you remember using that term?
Yes.
And differential diagnosis was really just a way for you to try to get your opinion to the jury that these injuries were not consistent with a car accident. That's what a fancy way of doing it is, right?
No, it was a method I used.
Differential diagnosis, you are claiming that you can say this is not from a car accident or a car collision. That's what you're trying to say, aren't you?
That was the result of my differential diagnosis and my pattern recognition methodologies.
If you're going to exclude...
He's like, you only did differential diagnosis to say that this was not a car accident. It's like, well, it would have been nice if some of your people did a little more work on differential diagnosis to prove that it was not a dog bite. And again, we may be seeing that in rebuttal, but looking at all sorts of different things and saying it's not that, which makes it even more likely it's this, is exactly what she did. And obviously a car accident was going to be one of those.
A cause of the injury, in this case, a collision. You have to know a little bit about collisions, don't you?
Yes, I don't know how to answer that.
No? Try.
Can you be more specific?
If you're going to say that these superficial abrasions could not have been caused by a car collision, you kind of have to understand a little bit about the mechanics of a car collision, don't you?
Actually,
he thinks he's going to get her with like that she's not an accident reconstructionist. She's like, I've treated literally thousands of people in car accidents. I don't have to be an accident reconstructionist to tell you causation for the injury. Frankly, doctors are in the best position to talk about causation of injuries.
Disagree. However, I've treated thousands of victims of motor vehicle accidents and have seen the wound patterns that they come into the emergency room with, and that forms a basis for me.
Do you really think?
I'm sorry. Did you finish that answer, Doctor?
No.
Did I cut you off?
I believe so.
Oh, I'm sorry. Please continue.
I believe so, right? She's still kind and calm, but she's smart. She's gotten her sea legs from first trial because she realizes you know what? Seems like Alessi wants me to finish this answer. I'm going to finish this answer. And this is how you dance with your lawyer, right? He's the lawyer. She's the expert. He objects saying she didn't finish her answer. The judge is like, did you not finish? She's like, no, actually I didn't. Because I feel like the last trial, she might've been like, no, that's fine. I'm done. But when you learn, it's like, no, let me finish my piece.
No, and the thousands of victims of motor vehicle accidents, I've looked at their wounds, I've treated their wounds, cleaned their wounds, touched their wounds, and that is what I use as a basis, part of my basis to determine that these were not caused or not consistent with a motor vehicle accident.
When you first gave that opinion that it wasn't consistent with the motor vehicle accident, it's fair to say you didn't have a lot of information at that time when you first came in and said that, correct?
Specific to this case?
Yes. Yes.
I didn't have a lot of information. That's correct.
Okay. And so in order to rule out a collision causing these wounds, let me ask you, are you an accident reconstruction expert?
Reconstruction? No.
Did you ever go to any academy for training to receive any type of degree or certificates in car collisions?
Actually, I did receive a certificate in hit and run accident investigation from the Massachusetts Criminal Justice Training Council when I was a police officer.
I was like, oh man, Hank, that sucks. Now he is going to discredit that a little bit because she honestly said it wasn't that big of a deal, nothing compared to my medical training. But I was like, oh boy, you asked that question. How many doctors can say what Dr. Russell just said? That's why, listen, you could say I'm glazing, I'm blowing smoke, whatever. It's like, I've got a lot of doctor witnesses that I've called at trial. Got a lot of accident reconstructionists I've called at trial, right? Very few can say, I am certified in this hit and run course. I was a cop. You know, very few can say things that Dr. Russell can say.
Do you agree that what training you did have was rudimentary?
It probably was, yes.
Well, not probably. You've used that word before. Wouldn't you say that any training you have had has been rudimentary?
In terms of accident
Yes.
investigation, yes.
Have you ever testified as an expert anywhere in accident reconstruction?
No.
Do you know what ACTAR is?
I got to be honest. A lot of people are like, oh, Hank Brennan's grasping at straws. A lot of times I think he's got a pretty good plan for Cross, but to go in on Dr. Russell and tell her she's not an accident reconstructionist feels a little like grasping at straws. It's like, why are you asking the medical doctor if she's an accident reconstructionist?
ACTAR?
Yes.
No.
It's a certification group for collision specialists, accident reconstructionists. Is it fair to say that you're not ACTAR qualified?
Objection, Your Honor.
I'm going to sustain the objection.
Are you ACTAR qualified?
No, and I don't know any physicians that are.
Have you ever gone to a scene of a car collision and done an investigation and written a report and reached a conclusion about the cause of the car collision and the injuries that were related to that car collision?
No, that's outside my scope.
It's beyond.
Duh. You're not the accident reconstructionist. Grace Bay said, isn't that basically implying no doctor could ever opine on the cause of injury when there is a car involved? That seems insane. Not only is it insane, it's just absolutely not how it works. Not how it works in any case ever.
On your expertise.
Beyond the expertise of
Yes, that's why she's able to testify here about causation of injuries, because that's not how it works.
a physician, yes.
Right. Yeah, yesterday you offered the jury your opinion that these wounds were not consistent with a car collision. Did you offer that opinion yesterday?
Wounds are in my area of expertise. So yes, I am very comfortable talking about wounds from a variety of sources, including motor vehicle accidents.
I'm sorry, I didn't want the siren to interrupt you.
Okay. Yeah, wounds are definitely within my area of expertise.
When you considered your opinion to this jury that this was not caused by a car collision, do you know what type of vehicle is in question?
Yes.
Have you ever studied the vehicle to look at the make, model, the height of different things like the bumper, perhaps the taillight? Have you ever studied that in this case?
I'm aware of some of those factors.
Have you
Yes.
studied that? before you
Studied.
Yeah, he'd like the study and the research and look deep into this. It's like, but he asks her about Welcher, right? And we know that Alessi already went through the Welcher test case. So now he's asking her about Welcher. Pretty interesting. I'm a pharmacist, and at every hospital I've worked, there are protocols on animal bites, dog, cat, spider, rat, monkey, etc., bacteria, etiologies, how to treat, etc. So I don't know why Hank Brennan is acting like an ERMD wouldn't be qualified, because he doesn't like what she has to say, which is not like abnormal from lots of lawyers, right? We challenge all sorts of experts, especially if they say things that we don't like or we don't agree with, or our expert says is completely wrong.
Yes, did you go and actually look at the photos, do any measurements before you came up with this opinion?
Not before I came up with the opinion, no.
Did you ever look at the damage to the rear taillight of the defendant's vehicle and see if it was in similar or the same height of Mr. O'Keefe if he was standing up? Did you ever do that?
I have looked at
And when
photographs.
you looked at the photos, did you see that a 6'1" man like Mr. O'Keefe, if he stood, his elbow would be the exact height of Miss Reed's broken taillight? Did you notice that?
I noticed that there was a similar, that the height would be similar. The height of the elbow and the taillight, yes.
Did you look at photographs of Miss Reed's broken taillight and see if where the break was corresponded closely or directly to the same height as Mr. O'Keefe's elbow and forearm?
I did.
And did you see that it matched up height-wise perfectly?
Close, yes.
I thought that was good that he got her to say that at least, right? That it lines up with the height. A lot of other issues, but again, there's a good point for Hank. We got to find them because they're like needles in a haystack with the cross for Dr. Russell. Pizza, be for real. I can't help it. The whatever, like pizza pan comes into my head every time I read pizza like this. Would you want to have a beer with Hank? Absolutely. I really would want to sit him down and be like, bro, this case, why'd you do it? Who do you know? Who are you friends with? He could have made this money doing something else. It ain't the money, in my opinion. After watching him this trial, I think he could have made more than this amount of money over this period of time in his regular law practice. So I'd be like, why? Why? This is not the one. And I would love to have a beer and ask him. I don't drink beer, so I'd get a Coke, maybe. Hi, Lori, fam. I was confused at the end because it seemed like Baros was confirming that Karen Reed's taillight was okay. Hold on, I'm gonna hold this one. Thought we had some questions on. Peter, is your shirt also a towel? Well, it certainly could be in the summer in Florida. A limo versus a police escort by Tully for Dr. Welcher. Is Hank Brennan pot or the kettle? Oh, just wait till we get to Barros's cross, where some of the really great points Hank Brennan makes. It's like, very different than the questions you were asking your cops. Hank Brennan seems all too comfortable crossing a cop. Are jurors allowed to actively take notes? Yes. Don't you think the jury sees Hank Brennan as a giant D-bag? I honestly don't know. I've tried cases against certain civil defense lawyers where I'm like, they are such jerks. But sometimes they have good results. Usually when I try cases against them, it's not like, oh, I'm so great or whatever. So many of the cases, it depends on the case, right? You have a great case. It's a lot easier to do a great job, right? But and a civil defense lawyer can only do so much with certain cases. But I hear about track records of some of these civil defense lawyers that are just total jerks, and they say they do well in some cases. So does it seem like Brennan is trying to create doubt instead of proving a case? Absolutely. Absolutely. Kevin, Peter, do you have a lawyer or assistant begin drafting appellate arguments during trial so it is prepared, so it doesn't take too long to submit if needed? And in this case, would you definitely advise to do this? So the longer the trial, the more necessary you need this. Sometimes we'll have appellate counsel sit with us. Sometimes I'll just take notes on what day or what witness something happens. We always end up having to order the transcript. It's never actually written or done before. The trial lawyer has to be involved and realize where the big issues are, but we're not the appellate lawyers. So the appellate lawyers usually will say, listen, I trust you. Let me get the entire transcript, read it, and see what I find myself, because they know the appellate work better than we do. Why does the judge not say anything about Hank's comments, but does to the defense without objections? She needs to tell him to chill. And frankly, he should chill, but I think he's almost taking this like a defense attorney too. Appeal be damned. Let's win this trial so we can go out there and say we did it, she's guilty, and then let her take her chances on appeal. That's what it's starting to feel like. Unlike most prosecutors who really want to protect against an appeal, just like we saw in Lori Vallow. They're like, in an abundance of caution, law change, appeal, who knows what's going to happen? We want to do X, Y, and Z. If you were the defense, would you have objected or just sat back thinking, best not to interrupt Brennan ruining himself? That's why you have to choose when to object. There were multiple objectionable questions by Hank Brennan that Alessi did not object to and let Dr. Russell run. What is your opinion? I'm going to hold that one. Brennan asked the same question 37 ways in an attempt to confuse the witness and or the jury. Can defense object to ask and answered even though limit? Yes, but if he's changing the question, it might not be asked and answered. Brennan cross on cop about proper procedure, LOL. Yes, we are going to get there. Could the defense have asked Welcher about dog bites? Yeah, but why? Why? He probably would have just said, doesn't look like a dog bite to me. This is a car. Why? He's not an expert. He can't talk about it. Brennan opening the door, talking all sorts of stuff with Dr. Russell, lets her give her opinion, which we're going to hear a lot more of that. If you're going to make an opinion outside your expertise, Brennan says when saying that basically she didn't go do the accident reconstruction. Objection obviously sustained. We're going to get into a little bit more here of her testimony.
Several different positions.
And when you considered that, what did you conclude as far as Mr. O'Keefe's body movement at the time of any potential impact?
Oh, first of all, I didn't see any medical evidence that there was an impact. There were no significant injuries from the neck down, no fractures, no bruise, no internal injuries, no lacerated organs, no collections of fluid in the lung cavities, the abdominal cavity, no significant injuries from the neck down. And
that's what I say when I say this was a bad crosser. It doesn't mean Hank Brennan's a bad lawyer. It's you're just trying to do too much, Hank. You're trying to do too much because every time you're not talking and she is, it's bad. And she's digging a deeper hole that you're in. And she's convincing herself more. She's convincing the jury more. I don't know how many times she said, yeah, you know what? I am even more sure now than the first proceeding. And you just don't want a witness like this up there talking as a lawyer. She has said her piece. The defense team got to ask their questions, make your points and sit down. He tried to battle with her way too much, just from a lawyer's perspective, in my opinion.
And so, yes, I used that and tried to put that in a scenario of his various positions. What could he have been standing, kneeling, sitting, lying down on the ground? I did all that.
You were a police officer before you went to medical school, weren't you?
Yes.
You had arrived at scenes of many, many car collisions, hadn't you?
Yes.
What is oftentimes left behind after a car collides with an object?
Debris.
Debris field, yes? Did you look at the debris field in this case?
No.
In the cases that you went to wherever you saw car collisions, some of the debris that you would find could be broken glass or broken plastic. Isn't that fair to say?
Yes.
And when you went to those scenes, you would often find broken glass or broken plastic in a debris field near where the victim was found or laying. Isn't that fair to say?
The debris field would be usually near the collision, if there was a collision impact.
And when you were considering excluding car impact or collision in this case?
She also did a really great job of saying alleged impact, alleged collision. If there was a collision, you say there's a collision. That's, I mean, from a lawyer's, it warms my heart when a expert remembers to do that and doesn't just start agreeing with the lawyer when he's talking about a collision or an accident or an impact, because you understand the question and where he's going.
Did you take a look at the entire debris field to determine how close or far it was from Mr. O'Keefe's body?
I couldn't tell on
Did you
the
ask any
photographs.
question? I'm sorry, please finish.
I couldn't tell from the photographs.
And before you came to your conclusions, did you ask anybody for any more information so that you could make a fair assessment of that information?
The injuries here were so characteristic that, and they were so parallel to one another that I couldn't even imagine pieces of glass or plastic or even metal lining up to cause those injuries, lining up in a...
She's like, it was just so obviously not from a taillight that I didn't really care about the pieces. Now, will some jurors be like, oh, she didn't consider that? Maybe. But to me, it's like, that's not what you want to hear when you are directing her. When you're giving the answers in your questions on cross, that is not what you want to hear. It's like, she's like, it was so obviously a dog scratch and bite that I didn't really care where the taillight pieces were. It's not great. Hey, thank you so much. And Azam, hit the like and subscribe if you haven't already. Road to 1 million. I can't even think about that. Cannot even think about 1 million subscribers. 500K is insane. I'm trying to do my best to be content with that, but I can't help but always want to grow and push. So thank you, Azam, for feeding into that even more.
In a certain fashion to cause those regular striations.
Rather than imagining, did you make any effort to
He takes a shot at that. She says, I could never imagine. He's like, rather than imagining, it's like, don't think that's really what she meant.
actually seek information so you could identify and evaluate the debris field around Mr. O'Keefe's body that morning?
I did not.
Have you
All right. So then Hank Brennan decides to dive into a new topic area. Like, do you consider statements in an accident? And she's like, yes, if they're credible. And he starts getting into the defendant's statements. He thinks he has an aha moment where Karen Reed has confessed, and he wants to ask Dr. Russell what you do with a confession like the one Karen Reed gave in this case. But before we get there, I'm going to answer a couple questions. I did a mock trial at Ohio State. I'd try this case better than Bev. LMAO. The memory question upset me the most with Dr. Russell. I sobbed at work. It's a hard day for me anyway, but this hurt me for her. He didn't have to be like that, but I'm hopeful the jury felt the same. She's so intelligent and well-educated. I don't know anybody on the jury that wouldn't have been like, bro, come on. Especially after Dever and after some other witnesses that have had serious memory issues. P, in general, do juries seem more forgiving to a defense attorney being snarky or the prosecutor being snarky with witness? I don't think they like lawyers being snarky. Most of the time, they side with the witness, right? Unless the witness is an abject jerk. They usually are with the witness. And like, come on, lawyers, don't be a jerk. What's your opinion on the judges? Whoops, I keep doing that. I will come back to that one. If the Commonwealth removes the car from the equation and claims bounced off it unharmed, then slipped and fell later, does that make Karen Reed not guilty? Like if the car bounced off of him, I don't know what that means. If Karen Reed did not cause his death, they lose. But if she did something with her car to cause his death, then they can still get a guilty verdict if they prove that. Brian B. ordered 2 shirts and a coffee cup. What a bargain. And John just told me that for any comments coming in about the merch discount, the code is LYK, 500K, and it's live until the end of the day tomorrow. If you want the merch, it is on discount. You do have to hit the like button on this video first. Just kidding. BA should have asked Dr. Russell if she's ever lied on a CV after Hank Brennan's question on accident reconstruction. I mean, I might ask every one of my experts that, honestly. How long do you think it'll take for channels like yours to noticeably shift juries, as in more public awareness of the rules, less likely to be swayed by typical defense or prosecution techniques? It's already happening. People are emailing me and be like, I'm so happy I was on a juror. We talked, other jurors, it was kind of frightening what they thought, but once I explained it, they were like, oh yeah, that is what they said. I think it's happening on a very, very minute scale, right? One at a time is kind of all it can happen, but I think it's incredibly important for our justice system for people to understand how this works. Peter, maybe I'm way off here, but I got the feeling Brennan did this to Dr. Russell because their ME could not rule it a vehicular homicide. Thoughts? Yeah, but I don't think this helped. I really don't think this helped, personally. Yes, you get the merch discount, LYK 500K. All right, so here we go. Hank Brennan asks Dr. Russell, but what do you think about these statements made by Karen Reed?
Opinion?
And some of those statements, after you rendered your opinion, did some of those statements come from the defendant herself?
Yes.
And when you listen to those statements, did you hear any of them talk about the idea or issue of collision or impact?
Yes.
And when you listen to those statements after you formed your opinions, did in any way change the analysis of your opinion?
Absolutely not. And I'll tell you why.
Please do.
Because she had, the defendant had undergone a very stressful event, finding her loved one in the snow.
By the way, this is a medical doctor with lots of experience that's going to tell us how this works. Which anybody, I mean, I don't know if there's anybody else that Hank Brennan could have objected to. By the way, you know, lawyers in the Depp trial, this guy's objecting to the answer to his own question. And sometimes lawyers are like, oh no, or judges like, no, you can't do that. Sometimes they're like, okay, fine. It's outside of her scope of knowledge, whatever. And it's embarrassing when you object. You're like, I still probably would have tried to object to my own question here. Because that would have been embarrassing myself on not national TV, whatever you call this, streaming live around the world would be better than letting the jury hear Dr. Russell's answer. That is now in evidence, and don't underestimate that because that is now something the defense can use in the future and argue in closing argument. There is a legit medical reason for why she may have said something like that.
She had, the defendant had undergone a very stressful event, finding her loved one in the snow. And so after a stressful event, many people suffer from what's called an acute grief reaction. It's very common. And they do things.
Very common. Like this wasn't even a hard call.
Acute grief reaction. It's very common. And they do things that seem to be irrational. They ramble. They act bizarrely. They make statements that are irrational, that don't make sense. And they oftentimes tend to blame themselves for whatever has happened. I've seen this many, many, many times in the emergency department.
Does this happen moments after a stress?
In the emergency department, which is where she works and where she's the expert and where people go after traumatic events.
Event?
Oh, yes.
Does it happen months later when you go on 20/20 or Nightline?
I've never seen that situation.
No. Does it happen?
She just answers it honestly. She's like, it's very unusual. I don't know. And, big deal, whatever. He asked those questions. That's already in evidence to me. I just do? Okay. Then we get into the dog DNA discussion, which we're going to take some time on. Let me see if I want to answer any more questions before we get to that. According to Sue, the jurors have been furrowing their eyebrows like they were quite turned off in Brennan's cross, but it was quite different with Alan Jackson. Grain of salt, I know, but thoughts on reasons. I mean, it doesn't. Alan Jackson, by the way, I think a lot of us are bringing in from the first trial. He was much more of a bulldog the first trial. I don't necessarily know if this jury sees him as a bulldog. I think he is. I think he has that in him, but I think he's been a lot more calm this trial. So I think that between him and Brennan, they've got to like Jackson more, I would think. Megan, why is Hank Brennan so annoying? Would anyone watch him in this trial and think I'd like to get a beer with this guy? Apparently me, because I have some questions. But I get what you're saying. But we'll see if the jury agrees. Couldn't the defense say Brennan was badgering the witness with Dr. Russell, or is that just an objection? It's an objection, and really he wasn't badgering her. He really wasn't badgering. If anything, he was like trying to badger or take shots at Alessi. Zach, congrats on 500K. Bev was the attorney for my uncle when she was a public defender, and Brennan used that case for case law on an objection early in the case. Does Bev need to disclose she was the lawyer in that case? It doesn't matter. She can disclose it. She can't. Usually judges love it. Judges love when they're the judge in that case. Lawyers love when they're the lawyers in that case. That's not something that's going to restrict her from being able to rule on something like this. Debris will be near the site of the collision, not the body. Did you catch that? Yes. I'm not sure that that's, I guess I should say I've seen it both ways because debris can move, bodies can move, things like that. All right. Let's now listen to some of Alessi's argument where he was very angry when Hank Brennan starts asking Dr. Russell, but there was no dog DNA. They swabbed it. They didn't find any of it.
Honor. Attorney Brennan, just with regard to Dr. Russell, in open court in front of the jury, used the concept of DNA in this case. He has introduced it and brought it in for the very first time in front of the jury. He has done so intentionally. He intentionally brought up DNA. Based upon that intentional mention, the defense moves strongly, vigorously for a mistrial with prejudice. A mistrial with prejudice. There has been no mention in this trial of DNA with regard to the topic, with regard to what Mr. Brennan has raised. There has been none. Specifically, the prosecution had, in the first trial, had a witness, Terry Kuhn, with regard to DNA. For whatever reason, the prosecution has chosen not to bring that witness in who would testify perhaps to DNA. As a result of that strategic decision that the prosecution made, there's been no mention. I want to be very clear. The defense has been incredibly assiduous and meticulous about not mentioning DNA in any fashion, directly or indirectly. With regard to the hoodie shirt and the hole, the only thing that was adduced in direct examination was a mechanical function, simply of Dr. Russell testifying that a dog tooth went in and came out and caused a certain mechanical effect on the yarn. Nothing even close to the mention of DNA. With regard to representations that Attorney Brennan has made, that somehow there was a hearing that we were on notice, it is completely incorrect. Show me the hearing, show me the transcript where that has been discussed. The prosecution has also said, we are going to, or we always intended to bring on rebuttal, Dr. Crosby, who would talk about the supposed absence of DNA, the alleged absence of it. The problem with that of trying to rescue the mistrial that the prosecution has caused with prejudice is that Dr. Crosby could never testify about such a topic, because I would object and object because there would be no foundation, because the prosecution strategically chose not to bring in the foundation whatsoever in this trial. The fact that they did it in another trial, or perhaps did it, is irrelevant to this trial, as Your Honor has admonished several times. What happened is, this is a new trial, and whatever happens in the first trial is the first trial. So in conclusion, Your Honor, because of the conduct of the prosecution, and specifically the intentional mention of DNA, the prosecution has put in the jury's mind that topic that is irremediable. That cannot be reversed. That cannot be cured. That cannot be ameliorated with a jury instruction. That cannot be dislodged. The prosecution has to suffer the consequences of its own intentional actions of bringing up that topic. Ms. Reed is entitled under the Constitution, under the Massachusetts Declaration of Rights, to a fair trial. And what has just happened is antithetical, abhorrent to a fair trial. The only remedy is a mistrial with prejudice.
Okay, thank you.
Brennan gets up and is like, doesn't matter how loud they scream or how much they bang their hand. We're just undermining their theories and we're allowed to bring something up on cross. And frankly, part of Brennan's argument is correct that it doesn't have to be an evidence if Dr. Russell considered it in her opinion. The problem is, and the same thing happened with when they start to get a little voir dire about whether Dr. Walsh's testimony can come in, if she considered it and disregarded it or didn't consider it as part of her opinion, Judge Canonia said you can't bring stuff like that in, like Trooper Paul's report with Dr. Welcher. But then later, she let Walsh's report come in, which I thought was very strange. I don't know what happened at some sidebar. It was very confusing to me. But Alessi is right in that Hank Brennan is now testifying as if something is in evidence to try and impeach Dr. Russell on cross-examination when they didn't bring that witness, didn't give the defense the right to cross-examine that witness, to poke holes in it so that the jury would already know whatever issues would have come out with who swabbed the DNA, who tested it, how they tested it, when they swabbed it, what they swabbed, where the clothes were before they swabbed it. And Russell does a pretty good job of trying to handle that herself. Like, these clothes were on the floor of the hospital and they were swabbed days and days later or whatever. I can't remember exactly what she said, but she tried to deal with it. But that should be done in cross-examination before it is brought to the jury's attention. And instead, to have facts brought to a jury's attention as if they're in evidence by a lawyer the first time is a major issue. Of course, Judge Cannoni denies their motion, no mistrial. But then she took it a step further. Not only did she not grant the mistrial, she's like, you can ask her about the dog DNA or lack thereof. I was like, okay, I didn't see that happening. So while I can understand that cross-examination should be broad, and if things came in that she looked at, their reliability, she's allowed to question their reliability if they're part of the case file. I get it. But this is also a situation where Judge Cannoni is allowing the Commonwealth to use things as a sword and a shield. We're not going to call the DNA person, so that's a shield. You can't ask them questions. But we're also going to use it as a sword with Dr. Russell to try and prove this was not a dog bite. And that's just not how it's going to be. And guess what? She could have let him talk about it. She could have said, yes, Mr. Brennan, you can bring up this dog bite issue and you can talk about this dog bite issue. But you've got to call your dog bite expert first. Sorry, your dog DNA person first. And they could do that if they went the differential diagnosis route to prove that this was not a dog bite by using a differential diagnosis. Peter, do you ever get as passionate as Alessi did when arguing for a mistrial? Congrats on 500K. Yes, many times it comes when you're frustrated with the judge. To me, it's like when I'm frustrated with the judge and how they look at my client, as if my client's not a person, right? And that does happen sometimes. Or when a defense attorney looks at my client, it's like they're not a person. It's like, Judge, we're all lawyers here. It's our job. But let's not forget, somebody's life is involved here. Maybe not quite the same way he does, but yes, it does happen. It's denied. We talked about the Walsh stuff. Brennan brings up the Welcher test case, and he's like, there's no lower body fractures. She's like, yeah, but major internal injuries. And she gets another opportunity to explain the difference, which Hank Brennan afforded her that opportunity. His DNA was on the car. How do you reconcile that? She's like, well, he's been in and out of that car lots of times. And Brennan's like, are you an advocate or are you a scientist? She's like, I'm a scientist. I'm just an expert. I'm not an advocate, but that's just is what it is. All right, now we're going to get into the dog DNA and we'll kind of hear how that exchange went.
Well, are you aware of that?
Yes.
You've heard of UC Davis, haven't you?
Yes, and in reference to that previous question, however, the swabbing was done many weeks after the death, and there were images of clothing on the emergency room floor. So yes, I am aware that there was some swabs taken at some point.
I thought that was a pretty great explanation from her, right? To weave in the defense, their theory of the problem with all this evidence.
Is that gratuitous answer part of your advocacy or part of your medical objective opinion? And so you're aware that these holes were swabbed to send a sample to UC Davis, aren't you?
Yes,
UC Davis, do you understand they specialize in dog DNA?
animal DNA, I believe.
And you also know, and giving it before you gave your opinion, that when they were tested, there was no dog DNA found in any of the samples. You knew that, right?
Yes,
In fact, what was found was pig DNA,
that's correct.
and there's no identification where the pig DNA came from, is there?
I don't think so.
So when you saw the information, after you claimed there was a dog, prove it, John O'Keefe, when you saw the information that they were swabs done of those holes and the results were no dog DNA, did you consider that before giving your ultimate opinion?
Yes,
And in fact, you've tried to discount the significance of that evidence in the past, haven't you?
yes,
In fact, you have made claims about that evidence candidly with no foundation whatsoever, haven't you?
I explained why there could be no dog DNA found.
You were claiming that it was inconsequential because a number of speculative reasons, didn't you?
So the objection sustained.
That was objection argumentative, like people were saying before. So individual questions that are argumentative, but he's not badgering her. Additionally, I have noticed the defense lawyer specifically giving a little bit of a reason for their objection, which I like. And Judge Canoni, to me, has made better decisions when they're allowed to do that. And she hasn't cut him off or told him to just say objection.
When you were discussing the absence of dog DNA on Mr. O'Keefe's sweatshirt in the past, were you trying to make suggestions that perhaps the samples could have been tarnished or compromised in some way?
That's one possibility, yes.
As a independent, objective expert, should you deal in possibilities, or is it a better practice, best practice, to deal with objective criteria in the form of actual opinions to a reasonable degree?
Wrong. Possibilities are great for the defense. We'll hear her question in a second. Peter, how biased was it for AB to let in DNA that wasn't in evidence? I thought it was horrible. I thought it was horrible too. Especially, here's the thing. Truth and justice are important. And if there was no dog DNA, let's get that out there to the jury. But they chose not to call that. That's the big issue here. It's not that he asked the question. It's not that they talked about the lack of dog DNA. They should be able to do that if they want to. They could have put that on in their case in chief, and they chose not to. That was the problem. That was the real problem.
Of certainty.
It would be best to go through a process to determine, or at least come up with a list of reasons as to why dog DNA was not found. There are a number of reasons. If you have a test in medicine, you expect it to be positive, and it's not positive. You go through a process of trying to figure out why the case is that way. There are many reasons why there could have been no dog DNA found.
When you first gave your opinion, you didn't even know.
I don't think Alessi, I'm just based off pure memory, I don't think Alessi dug into that at all on redirect, did he? Which I think was probably smart to not dig into it for the appeal. Somebody asked, can they appeal the mistrial now? No, this will be something after the case.
Know about that DNA testing, did you?
Not initially, correct.
But then once learning about it, you were not willing to reconsider and change your opinion about the source of these scratches. You maintained the same opinion you had before, correct?
I reconsidered, however, my opinion did not change.
What you suggested is there's possibilities, is the word you would use, possibilities why there were errors with the DNA. Yes?
Yes.
You can't tell us anything based in fact. Wait,
No.
I'm sorry.
Sorry.
You can't tell us anything based in fact to support the claim that something was wrong with the testing of this DNA, can you?
Not in fact, but again, you have to go through a process. If you expect a certain diagnosis or a certain finding on a lab test and it doesn't materialize, then you wonder why. And you want to know, was the test done correctly? Was the specimen handled correctly, et cetera, et cetera. There's a process.
And in that process,
Great questions by her. And I'm playing this. We'll talk a little bit more about the mistrial and dog DNA issue after we're done with this section. Farmer Whitehair, I might have two. Might have two Cokes with them. Might even buy their Coke, right?
process, you found no evidence whatsoever, none, zero, to support any claim of compromise of that DNA process, did you?
Well, ideally, the swabbing should have happened immediately or very soon after the incident. So there was a delay in processing or swabbing to begin with. And then, of course, I don't know about the transportation or the chain of custody.
You were a medical examiner, weren't you?
Yes,
When you were a medical examiner, when you examined a person or their body, you did everything you thought was reasonably necessary based on the information you had, correct?
yes,
Did you know at the time Dr. Scotabello did the autopsy, there was no claim whatsoever that a dog caused these wounds?
yes,
Did you know that claim didn't come about until over a year later?
no.
And did you know that in response to that claim, that's why this was done at a later time? Did you know that?
Still, for a complete investigation, this should have been considered by investigators early on.
Even with
So it's, again, somebody else's fault that the Commonwealth and law enforcement did not do a complete and proper investigation. You know who could answer something like this? Mr. Easter, the law enforcement expert, which the defense filed a motion for reconsideration. I thought he should have been let in the first time. I think he should be let in again. I don't think anything that's happened in this trial is going to change Judge Cannoni's mind, because it basically came out exactly how we thought it would, minus Proctor, right? We're not a lot of surprises. It was a horrible investigation, just as horrible as we remember from the last trial. And Dro knows. It's a tough one. But basically every lawyer could ask her this question. And the answer would be, yes, she's smarter than us.
there was absolutely no claim or evidence whatsoever that a dog caused these wounds.
Well, again, a complete investigation.
You can't
He's like, complete investigation fixes a lot of the problems in this case.
tell us one step that went wrong with that DNA process, can you?
The process, no.
In fact, you have admittedly very little experience with DNA.
I have little personal experience with DNA.
And yet, although you're not an advocate, you are willing to advocate trying to undermine the strength of that evidence, aren't you?
No, I am a scientist, and I'm trying to understand why it could have been negative.
As a scientist and providing a medical opinion, do you try to exclude in your differential diagnosis all other reasonable causes of a wound?
Generally, yes.
And did you do that in this case?
Yes.
Now, when a dog bites a sweater, would you expect that it would leave DNA?
Yes.
When a dog bites a sweater, you would not expect it would leave little fragments of taillight shards enclosed, would you?
Correct.
And so in this case, when you were developing your theory and differential diagnosis and excluding causes, did you consider that when Mr. O'Keefe's clothes were scraped, his pants and his shirts and his sweatshirt, what was discovered were minute, small fragments of broken taillight that came from the defendant's motor vehicle?
Objection, Your Honor.
I'm going to level.
Did you consider that?
I didn't know that at the time.
Could we have 201D, please?
I kind of feel like he should have ended right here, because he got her to agree that there should have been dog DNA there if the dog bit, because they have, saliva and whatever in their mouth. There are fragments in the sleeve. You wouldn't expect those fragments to be there, and fragments can scratch an arm. All right, that's all I've got. Sit down. But he keeps going and ends up, she says, they can cause abrasions, but not in that pattern. Multiple times. And he asks it again. He's like, are you saying that the taillight could not have caused this pattern of injury? And she's like, correct. And that's basically how he ends Cross. Very few good points that he made, but I thought that was a pretty decent one at the end. I would have sat down right there. Then Alessi comes up for redirect. He's like, can you see how small these shards are? Could these little microscopic pieces of plastic really have caused those wounds? And she's like, no way. No way. She reads the articles, a lot of what she testified to about how that's her background. There's some highlighted parts we'll get to later. She again explains differential diagnosis. And then they get into the blue paint experiment from Dr. Welcher. And Alessi is going to take this opportunity to have Dr. Russell discuss what she sees and what she learned here.
Russell.
Oh, by the way, I said I was going to talk a little bit more about the mistrial. So from my perspective, I'm not surprised Judge Cannoni denied it. I think after we heard it, it was effective, maybe not as effective as it could have been because of some of her explanation. So maybe an appellate court would not find it material, but it is a pretty big shot in a dog bite case if there was no dog DNA there. And to let them bring it in this way was very inappropriate. Now, will they say it was going to inevitably come in anyways, or they could have brought it in. So it's not like they got in inadmissible evidence. That would have been very different if they tried to use some, hearsay statement that was never going to come in versus this that could have come in and still might come in on rebuttal, which Alessi said would not cure the problem. Will an appellate court agree? I don't know. But it's a major problem. I don't think we can discount how important it was to take that shot at the dog bite theory by having Attorney Brennan testify there was no dog DNA there. All right, now let's listen to this chunk on redirect.
Can you see what is depicted on that slide?
Yes.
Is that impact that is depicted on this slide, is that a clip or is that a direct impact to the arm?
I believe that that's a rather direct impact.
Okay, so this is a direct impact. And now, from your experience, and you were asked about this on cross-examination, a direct impact to the arm, assume, as was discussed, a motor vehicle, 6,000-pound Lexus going 24 miles an hour in reverse with a direct impact on the arm. From your experience as an emergency medicine physician, what type of injuries would you expect to this arm?
So I would expect at least significant bruising, at least. But I would also expect fracture, possible dislocation of portions of the arm.
What portions of the arm would you expect fractures and dislocations?
Well, from this image, if it impacted that section of the arm, and let me use my pointer, right here, a very good possibility that there would be a radius and ulnar fracture of the forearm or an elbow fracture.
Could you please stand up and with your
Which is exactly what a lot of us have felt this entire time. Thank you, Lorraine, for being along for the ride here. And thank you, Melanie, for gifting 20 memberships. And to everybody gifting memberships, it's going to be a fun one this time because we're going to talk a lot about the 500K celebration. We've got new merch. We're going to be doing giveaways and stuff at the Members Only Live for June. Peter, why don't you drink beer? Sorry, watching late. I don't like it, number one. Number two, I have like an addictive personality when it comes to stuff. I'm like all into it. So that's why I try to avoid alcohol, period. Number three, it's like every bad thing that happened when I was in college or like nights like the Karen Reed night, alcohol has been involved. So I just try to stay away from it, right? As best I can.
Your Honor's permission, show where the radius and where the ulnar bones are of the arm. Lights on, please. Thank you. You can keep the lights on.
So the radius and ulnar are the two long bones in the forearm right underneath the skin. And then they join with the humerus bone here in the upper arm at the elbow. And those, of course, these bones are they're susceptible to fracture with a significant impact. And also the elbow would be susceptible to fracture.
How about the hand?
The hand could be injured. It depends on where the hand was in relation. And also, if there was a fall, there are other mechanisms that could contribute to a fracture from the actual fall onto the ground. So there could be a wrist fracture, digital fractures. It depends on the circumstances.
Thank you. And do you can be seated. Thank you very much, Dr. Russell. From a direct impact to the arm, as you said, is depicted here. What is the likelihood of there being any fracture to any bone?
Sustained in that form.
Do you have an opinion based upon a reasonable degree of medical certainty as to whether there would be any fracture to any bone?
I believe that there's a very high likelihood that there would either be a significant bruise or laceration or a fracture of the bones.
Now let's go to
None of which, unless you want to call the scratches a laceration, which I don't think she means them as the same thing, none of which occurred here for John O'Keefe. And he got her to say that again here on redirect. Then they get into Scorty Bello, what she did, a very extensive examination of the lower extremities inside and outside, found no injuries. Neither did Dr. Russell looking at the photographs, including the bruise to the knee. There was absolutely no injuries under that bruise, abrasion, whatever you want to call it. Brennan gets up on Recross and basically says, who highlighted all that stuff? Alessi. Well, no, I suggested it to him. He highlighted what I suggested. Okay, again, definitely there's going to be arguments from Hank Brennan that the defense is coaching their witnesses, telling them what to say and what they want to say and not want them to say. He pushes again that she's not an accident reconstructionist. Okay, then we get to a question so many of you guys have, and finally somebody asked it. What about the fact that this body's in the snow is that going to have the type of effect that would basically be like icing that injury? And is that why there were not more bruises or swelling, things of that nature? By the way, we're in overtime again. We're definitely not going 2 hours today, maybe hour and a half-ish. Make sure everybody hits that like button if you have not already. Being here an hour, hang out a little bit longer. We still have a very important witness to talk about. We're almost done here with Dr. Russell.
Nerves underneath. And then, and of course, you want to examine adjacent structures for fractures and other injuries. And then after all that, if you've ruled out major, other injuries, you treat the patient for pain.
You ever prescribe ice?
Oh, yes.
So if a person was lying prone in the cold winter on the front yard on the dirt and was being covered by snow, sub 32 degrees, and the body temperature were to drop from 96.8 to about 80 degrees, would that have a similar effect to ice on the area that may bruise?
Not exactly. You want me to explain?
I do.
Okay, yes. So as the snowflakes fall, yes, there will be a gradual lowering of the body temperature and gradual effect on the body. Now, as opposed to in the ER or in a medical setting, if I or another practitioner, and by the way, nurses and nurse practitioners and PAs also treat dog bite wounds. But if another practitioner, a practitioner gives the person an ice pack, they get immediate coldness and immediate significant change in temperature to that area.
Assume the weather is so cold that the cell phone battery on someone's iPhone begins to plummet regularly in degrees.
I have no idea.
Objection, Your Honor.
The objection sustained.
Yeah, it's like, nice try. But good question by Brennan if it's going to help him. But what it sounded like she said is it would be gradual. So bruising, and unless he didn't ask this, but maybe I would have asked it. I don't know if he knows the answer. But so how long would you expect it to take bruising if a 6,000-pound car hit somebody in the arm going 24 miles an hour? The bruising would be pretty quick. It wouldn't take 5, 6, 7, 8 hours as the snow fell. I would think. I don't know. She didn't testify to that, but that could have been a good follow-up question potentially for Alessi. Okay, there was a redirect. And Brennan was able to ask about Walsh's opinion, which was basically that Walsh disagreed with her. And once I heard Alessi read Walsh's full opinion, I was like, maybe the defense wanted this in after all. Maybe that's how it came in. So let's take a listen. This is after Hank Brennan was like, Dr. Walsh disagreed with you, didn't he? And she's like, yes, but I disagreed with him. I don't know what his background is. I don't know what his training and experience is. So, I like to know that before I really give a lot of credence to somebody's opinion. And unless he's like, let's read what Dr. Walsh's opinion really was.
May I proceed, Your Honor?
Yes.
Thank you. Dr. Russell, I am handing you this letter from Dr. Walsh. And what I am going to do, and you just tell me if I do it correctly, I'm just going to read 2 paragraphs, okay? And you just tell me if I'm reading it correctly. In totality,
Terry Smith, I would add Dr. Walsh to your list here of doctors.
I'm going to read 2 paragraphs, okay? And you just tell me if I'm reading it correctly. In totality, the injuries documented in the autopsy report and photographs are non-specific and may be the result of a variety of different mechanisms. No additional information was provided regarding the possible circumstances or events surrounding the death. The absence of additional information prohibits the attribution of injuries and contribution of findings to a specific underlying cause of death. Did I read that correctly?
Yes.
No further questions, Your Honor. Thank you, Dr. Russell.
Yikes, that was a boss moment. So I don't know if that went under the radar. I didn't see a lot of people talking about it. I didn't get a lot of messages or question about it. That was a haymaker to end. Even Dr. Walsh, who says he doesn't think it was a dog bite, is like, we don't have enough information. This could be so many different things. And what we have does not tell us what it is. So it should be undetermined, which is basically what Scorty Bello said. So basically every single doctor that has come in here has said, I cannot tell you that was from a car accident. We have one saying so far that it was a dog bite or a dog attack injury. That was huge to me. Again, because that's the big part of this case is I look at those injuries, that doesn't line up with a car accident to me. And even Dr. Walsh, who Hank Brennan was peddling against Dr. Russell, even he is bad for the Commonwealth when it comes to that. All right, let's run through some questions before we get to Mr. Baros. Can the defendant ask ARCA, hired by an outside agency, some agency, why its agents conducted interviews for other witnesses in this case? FBI already mentioned. I mean, They definitely can't say the FBI part, but can they say the same agency that was asking all these witnesses questions? I highly doubt it. CS Squad. Hi, lawyer, you know, fam. I was confused at the end because, golly, I keep reading this one. All right. Well, I'm going to save the Barros ones for Barros. Peter, do you think both sides have started to draft their closing arguments? Is it too soon? They probably have some kind of shell or outline, but nothing, just like bare bones at this point. Peter, can we safely assume that mentioning prior trials numerous times, the jury knows the second trial? They'd have to be really dense to not know this is a second trial. What is your opinion on the judge's ruling for the mistrial with prejudice and opening the door for facts not in evidence? I disagreed with it. I think it could be potentially reversible error. I do. But I do think there's ways that can still be affected down the road. Ashley, thoughts on if a not guilty verdict is more likely now? Well, we're about to get to Barros, and I think absolutely more likely. Am I like super confident it's going to be not guilty? I wouldn't go that far because you just never know what a jury's going to do, but definitely more likely today than it was yesterday. Did Barros get called to the commissioner's office like Officer Snarky? I don't believe so. Okay, this is a Barros question. Dr. Russell was there to testify about injuries on John's arm, but Mr. Brennan asked her all these other questions. Why did they allow this to go on? Because you are allowed to try to discredit one expert versus yours and saying, he's saying Welcher's in a better position than she is. Will the jury buy that? We'll see. Do you believe some of these jurors are surely on the internet doing their own investigation but not fessing up? I surely hope not. I think it's possible, but I really, really hope not. Wish the defense would ask if it's possible that Karen Reed has a false memory like Officer Snarky did. Thoughts? I would not do that. I would not hit the Karen Reed clips that way. Peter, is this trial about facts and evidence or about making each witness look bad? Major cringe factor for Brennan if I was on the jury. Frankly, lawyers do this in every case where they really attack the credibility of witnesses, especially if they say something bad for them. But, I would say it's still about the facts and the evidence. I would say that. It's been mentioned multiple times that there was no snow under John O'Keefe's body, but wouldn't his body temp have melted the snow under him? I would have thought that too, but I try not to guess outside my scope of knowledge and what's been told to me in these cases, but I get where you're going with that. Michelle, Hank Brennan, Dr. Russell isn't qualified to talk about DNA collections and handling in a police investigation. Can the defense use this as grounds to admit Easter? I think they could add to. I don't think it was in their motion. I skimmed it. I don't think that was in their motion, but it's like, Judge, he's asking the wrong witnesses. Let's bring a witness that Hank Brennan can ask those questions to. Not surprised she didn't grant the mistrial, but I thought at least she would give an instruction to strike anything about dog DNA. Does the defense need a new expert now? Again, I don't think it was a surprise. I think the defense thought the Commonwealth was going to bring in the dog DNA. I just think they thought it was going to happen in their case in chief. And because it wasn't, they thought, oh boy, they're not going to be able to bring it up here. But little did they know the judge was going to be allowing it. Maybe I'm wrong, but didn't Hank say the left arm was swabbed, but the injuries are to the right arm? Pistol Pete, you the man. I missed that. If he said that, I missed it. It was probably just a misstatement. Thoughts on Tibbs? I was kind of shocked, but isn't this what always happens to Tibbs? He gets your team to a certain level, but he can't break through. How does the Commonwealth reconcile saying to Dr. Russell, the arm has superficial wounds, yet with Welcher, it was the point of the vehicle impact that clipped him and tossed JOK backwards to the ground? Which is it? They would say both can be true. Azam, Peter, if there are so many appellate issues after the verdict, will the judge of the trial face any consequences too? No. You don't want to have a lot of cases get overturned, but there's not like, if you do get overturned, you don't get punished as a judge. All right, let's jump into Nick Barros's testimony, who is a sergeant with Guyton PD, no relationship with Proctor, Higgins, Albert, etc. Buchanan. He was there when the Lexus was towed, and let's hear what he had to say, which to me was potentially a death blow to the Commonwealth's case. If the jury believes what Nick Barros said, how would they not think that there's no other explanation but the cops trying to pin it on the girl, smash the taillight, put it in, the place it needed to go? There are so many questions with this testimony, so many things that don't make sense, that I would be so far entrenched in not guilty at this point that I would say, do I really need to try to figure out if there's a conspiracy here? Because Barros has no dog in the fight. He has no skin in the game, and he is unequivocal about his testimony here, which to me is, how do you recover from this from the Commonwealth? This was potentially Hank Brennan's best cross-examination in the entire trial. Was it enough? We'll talk about that, but let's listen to the direct first.
had been seized formally by Trooper Proctor and Sergeant Buchanan, correct?
Correct.
Did you observe anything of note about the rear end of that black SUV?
Yes, I noted in a report that there was damage to the taillight,
Can you describe for the juror, by the way, which taillight are we talking about?
the right rear taillight.
Can you describe for the jurors what you noted in terms of the damage to the right rear taillight?
I noted that the report said that there was right rear damage to that taillight.
When you say damage, have you ever described that damage previously?
I have.
Can you tell us what that
Yep.
description is?
There was, it was damaged. The taillight was damaged, but there was a crack missing, but it was not completely damaged.
When you say there was a crack,
To me, he has always been, this was way further than he has gone in any other testimony. So I get why Hank Brennan was going to focus on the inconsistencies, but he was kind of vague in prior testimony to where now he could have just said, I'm being more specific now. It's not a different testimony. It's the same thing I always said. It's just more specific. But he didn't really do that. Brennan really battled well with him on cross. But I mean, this was A+ direct.
do you mean there was a piece missing?
A piece was missing.
Can you describe for the jurors kind of what that piece looked like, how big it was, how small, the shape, as you call it?
The piece was about maybe this big,
Is that maybe the size of a dollar bill, maybe 6 inches?
6 inches.
And
or so.
how wide?
Maybe that wide, maybe 3 inches, 2 inches, somewhere in there.
So 6 inches by 2 or 3 inches. Definitely not the 47 pieces we've seen, but it gets better.
I want to show you a photo. Your Honor, with the court's permission, I would like to show Exhibit 13. It's been previously marked. Do you see what's depicted in this photograph?
I do.
What does that appear to be, just generally?
The right rear taillight,
Of what?
the Lexus SUV.
Is that consistent with the black Lexus SUV that you saw at the Reed residence?
That was the black Lexus. That was not the taillight the day I was there.
Can you do me a favor, Mr. Wolk? With the court's permission, could we zoom in on the right rear taillight, please?
Okay.
Do you see the condition of that taillight as it's depicted in this photo?
I do.
Sergeant Barros, is this the condition of the right rear taillight when you showed up at the Reed household at around 3:15 in the afternoon on January 29th, 2022?
Absolutely not.
What's different?
Is that the condition of the taillight when you saw it the night morning, January 29th? Absolutely not. And it was highlighted over and over again in cross and in redirect. This is not how he saw it when it was towed from Karen Reed's house. So how do you overcome this? For anybody that doesn't think Baros was convincing, let me know in the chat, and don't jump on anybody, okay? This is for discussion. And maybe you've already watched Hank Brennan's cross. I'm going to play a lot of it here because it was meticulous in trying to really get Baros to admit his memory was not as good as maybe he thought. But that is as unequivocal as you can possibly be about testimony that is not what it looked like when he saw the Lexus before it went into the possession of law enforcement.
Different about this photo, sir?
That taillight is completely smashed out.
Does it appear that there are additional pieces of taillight that are removed from this taillight condition than when you saw it at the Reed residence? Okay.
Sustained. Ask it differently, Mr. Jackson.
Of course. Describe specifically, other than the fact that it's different, describe in detail for the jurors what is different about this taillight as it's photographed here.
That middle section was intact when I was there. Towards that right side where that large chunk is, that's what was missing.
I'm going to hand you a green laser pointer. If you can, there's two displays, one monitor directly in front of you and one to your right. If you could use the one to your right, it's a little easier on the jurors. Describe what's different about that taillight.
Can you see that? So this area was intact. This is what I saw was missing here.
May I approach?
Yes.
I mean, that is so much stronger and makes so much more sense and is so much clearer than the first trial. And I wonder if Karen Reed's team was like, holy crap, that came off amazingly well for them. EKG said Hank was up to his old tricks on cross. Brian B said, Barrows sent me from not guilty to factually innocent. I understand it. I get it. Would Bev all feds to test? If not, they're going to pursue this post-trial. Seems like all rules are off the table now, at least for the prosecution and burden of proof. We'll see. I mean, nothing's going to stop the FBI from doing whatever it is they want to do. Several sources have reported that one juror never takes notes. How can someone keep up with this kind of case without notes? Thoughts? It's juror to juror. And frankly, there have been multiple times where there's been one or two or a couple jurors that don't take notes. You're not forced to. Peter, how many times can the state keep going after Karen if it's a mistrial? Certain states may have rules, but a lot of states, they don't limit how many times you can retry them if it ends up in a hung jury in a mistrial. Okay, so that was the direct. He cleared the scene at 4:17, so the car was not seized at 5:30. He says the busted taillight, consistent with what you saw after 3 p.m., absolutely not. That is how the direct examination of Officer Barros ended. A lot of these questions are about cross. What stops a juror from watching your videos and forming an opinion? By the way, love how far Pops has come along. His confidence and humor has gotten so much better. I mean, the judge's order. They should not be watching these videos. I've said it from the beginning. They should not be watching any videos looking anything up where they are violating a court order and could be sanctioned. They really should not be. Why couldn't Alessi ask about acute grief on redirect? Yeah, I thought that was horrible. I thought he absolutely should have been able to. Brennan opened the door. Obviously a mistake. Obviously he shouldn't have, but he opened the door. In honor of your 500K, could you please play your old Johnny Depp pirate intro from back in the day? Classic. I'm sure some haven't seen it. We reserve that for the members only lives now. Not on the main ones. Not on the main ones. Question. After the FBI has been mentioned, can any evidence they have been introduced, or can the agents be called as witnesses regarding the interviews with any witnesses in the trial? Also, is it now permitted to refer to the FBI? As far as I have seen from the judge, the answer to all these questions would be no. But she could change her mind and allow it. I don't think she's going to, but nothing that's happened in trial and that I've heard her say on the record is lining up with allowing this. All right. So Brennan's like, you didn't write a report. You didn't take pictures. You didn't thoroughly or specifically describe the damage. I was like, that's rich. And I know some of you did too. I'm going to throw some of your comments up. That's like, wow, that's really the pot calling the kettle black. But Brennan is very comfortable cross-examining this officer. He asks, you met with Jackson. Where'd you meet with him? Hotel. Hotel? Did you think that was odd? It's like the conference room. It's like, these people are all from out of town. It's not that weird, right? It's not that weird. He doesn't have an office here, and Jackson brings that up on a redirect. I'm from Los Angeles. I don't have a house here. I don't have an office here. He said the last time you said there was a difference, they started arguing about what exactly Barros testified to last time. And Brennan, this is where he really digs in and tries to discredit Barros based on his prior testimony. And you guys listen, tell me what you think he did to Barros' credibility. Because he has to just destroy Barros' credibility to even have a chance at this thing not being, it's over. Like was it a football player that said it's over? I don't remember, but it's basically over. It's over. Oh no, it was a dunk contest. Vince Carter, it's over. That's what it felt like after Barros, after direct.
The looking one down there on the right?
No, it was not.
Somebody else?
Somebody else.
Okay. Was there anybody else there?
No.
When you were in that conference room, were you shown your police report?
No.
Were you shown your testimony from the last time you came to the court?
No.
The photograph of the vehicle in Sally Port, the vehicle with the missing glass, were you shown that?
No.
Had you ever seen that photo before?
Of course.
And you saw it at the last event you testified at, right?
Correct.
And when you were shown that photo during your prior testimony, you never, ever suggested that was in any way different than what you had seen in that.
Nobody asked me that.
You were asked to describe the damage, and you were shown that photograph. You never, ever suggested that there was a difference in the damage as you see it in that photo compared to what you remember, did you?
I don't think anybody asked me to describe that.
Did you ever make a note or say anything that is dissimilar to what you remember at the last event that you testified at?
I testified that was not the taillight the day that I saw it.
That's when you testified at the last event?
So Red's daughter, I think this is probably, more difficult to not do. It's just like their experience and what they feel versus actually looking something up online. But she does tell them not to do any of their own research.
Yes?
Yes.
You said that photo does not depict what you saw?
Correct.
Yes?
Yes.
And when you testified to that at the last event, who was asking you that question?
District Attorney Lally.
Okay. And you remember making that comment under oath?
So Brennan brought out, I think, Alessi was able to argue who called you last trial, the Commonwealth. Brennan asked him who was asking you questions last time.
I do.
Do you remember that as well as your memory about what the taillight looked like back in Dayton?
I do.
When you were asked questions about that taillight, you had described the taillight as not completely damaged. It was cracked, and there was a piece missing, but not completely damaged. Remember that testimony?
I do.
And is that accurate testimony?
It's accurate.
So he's setting him up, and it was weird. This officer did not read his prior testimony. He definitely should have. Cecilia asked, do you think Hank Brennan succeeded in his efforts to discredit the doctor and the cop? Definitely not Dr. Russell. He definitely, to me, succeeded in hitting the credibility of Barros. Was it enough? Was it material enough? He got Barros to make a bunch of admissions that we're going to watch. Voix said, congrats on 500K. My first trial bounced around, and this is by far the best coverage and community. You got that right. So I am now a subscriber. Thank you, counselor. Thank you for being here from Sweden, the last commenter, and this new one. As a Bulls fan, the Tibbs comment hurts, Pete, but it's true, right? I mean, you feel the same way. You've got to.
So in your memory, in June 10, 2024, was that vehicle's rear tail light had a piece missing, correct?
Correct.
You said that your memory about the damage to the tail light, as you recall it when you were in Dayton back on January 29, 2022, you said your memory is as good as your memory that you said in court there was a difference between that photo and the damage, right?
Right.
But you have a specific memory of discussing that specific photograph. Yes?
Yes.
Can I approach?
Yes.
And when you reflect on your memory, understanding some time has passed, you testify that your memory of distinguishing that photo is reflected in your testimony, right?
Objection.
Ask the question differently.
Your memory,
Greg said last year he testified exactly the same. Regarding the piece missing is not completely damaged. You just screwed up, misremembering being shown the photo last year. I agree. And that's what I'm saying. It was kind of a minor thing that the witness could have dealt better with. But the witness was giving Hank Brennan exactly what Hank Brennan want, and Hank Brennan drove a chuck through it. And when I was saying the witness was different than last year, it was just much more specific about absolutely not. This is the piece that was missing. It was a dollar bill size, 6 inches by 2 inches. A lot more detail, which is better. And if there is going to be an evolution in your testimony, that's the better way to do it than to completely change it. He did just misremember a small detail, which Alan Jackson tried to point out on redirect. I'm asking you how effective you thought it was. Everybody.
is that you discussed the distinction between that photo and what you saw at the last time you testified.
Objection.
I'm going to allow that.
And I should take a look at it.
So he's going to look through his whole transcript, and then Brennan's going to, or then he's going to say, it's not there, is what he ends up saying.
It's not in there.
Can I approach?
Yes.
I can put it back on. Thank you. So respectfully, sir, your memory about distinguishing that photo is not as you thought it was and claimed it was in this transcript, correct?
Correct.
And that's not a matter of you trying to fool anybody or lying, is it?
By the way, one thing that Barros, A+, demeanor, stayed calm. If he got caught and he was wrong, he said he was wrong. I think he gave Brennan a little too much when it came to how bad his memory is, because I feel like he just agreed a little too much with that. But overall, amazing demeanor, the same on direct and cross, very trustworthy guy generally, but Brennan did hit his credibility as far as how good his memory is. Not that he's lying on purpose, not that he's a jerk. That's not what I mean by credibility. I mean, he got this witness to admit that maybe some of his memories are not great. Maybe he did misremember things. Maybe he did forget things. Maybe he did testify different in other times that he testified. And that's good for a lawyer. That's a good job by Brennan.
No, it's a matter of time passes and memory fades. Yes?
Yes.
And that's one real example why the Academy.
Nuttall wouldn't agree with that, right? And this, I mean, Hank Brennan has no problem disregarding everything the cops on his side and the witnesses on his side said to use it here and I don't know if the jury's going to notice that. It was blatantly obvious to me, and I think a lot of you guys, that he is in the exact opposite position with this witness than basically every one of his witnesses. They were so much worse in the areas that he's cross-examining Barros on.
Academy, they teach you when you write reports to be as detailed as you can. We'll comment the fact that memories can fade, right?
Correct.
Memories can change.
I know what I saw, and that wasn't it.
Well, that's not what I'm
I
asking.
mean, that's a home run swing. I know what I saw, and that wasn't it. He's like, all the semantics you're trying to play here, brother, I know what I saw, and that wasn't it.
Yeah, because you just testified that under oath, you had looked at that photo and distinguished it. But that's not accurate, is it?
No.
And so it's not a matter of you perjuring yourself or lying. It's a matter of difficulties with memory, wouldn't you say?
Yeah,
And
correct.
you share those same
I mean, first off, objection, compound question, because anybody's going to agree with you. You say, it's not a matter of you perjuring yourself. Correct. I agree with that. But then he added on, memories aren't great sometimes.
difficulties with memory as many other witnesses.
Objection.
Sustained.
You have, as is human nature, difficulties with memory at times, correct?
Correct.
And so that
You have, as is in your nature, difficulty with memories sometimes. And he says, correct. This cross was good because of the answers Barros gave at times. I see you said, look at the SUV closely at one Meadows distortion while right side of the SUV and taillight. Maybe you can stop and show it, please. I'm unfortunately, I'm already at an hour and a half and I got to wrap soon, but there's still a couple things I want to get through. So I'm not going to have time on today's video to stop on that.
that very certain memory you had about your testimony last year, you're going to say that never happened.
Correct.
You were simply mistaken, weren't you? Or something more, please tell me.
Correct.
You were simply mistaken. And he's like, correct. Is it something more like you're lying on purpose and it's perjury is what Brennan's saying? And Barros is like, well, it's obviously not that.
When you met with the attorneys in Boston, what'd you talk about?
It was just a way for them to meet with me and see me face to face, and then ask me how I would be subpoenaed, who would they need to send a court summons to, what my schedule was like coming up in the next month, next months.
Those things all could have been accomplished by phone, correct?
Could have.
So the face-to-face meeting, what'd you talk about?
Objection.
I'm going to allow it.
Over here. What'd you talk about?
Excuse me.
So that, okay.
So I left that in there just to hear the part where Brennan or Jackson objects. It is overruled, and Brennan's like, over here. It's like that that meme that Leonardo DiCaprio meme. It's like, over here. Bring it right here. Eyes on me, witness. And Jackson's like, over here. He as he's walking to the bench, he's like, over here, because again, Brennan is saying this stuff in front of the jury in a trial where you're not even allowed to say objection, speculation. And he is making these comments in front of the jury. Stuff like this has happened to me before. It pisses me off, really frustrates me. And I'm like, judge, you got to do something. And eventually, if the judge doesn't, sometimes you got to take matters into your own hand and object vigorously and start some speaking objections, potentially.
For today,
Yes.
who showed it to you?
From seeing it on TV, and
Was it shown to you during your
Start talking about how he's seen some of the videos like of the tow truck in this case.
conference room meeting at the hotel?
it was not.
So you looked and studied and watched this case a little bit?
With all due respect, sir, I don't live under a rock. It's all over social media and the news. You can't avoid it.
I'm not criticizing you with this conference. I'm just asking you. Have you been exposed to this case since you made those observations indictment on January 29, 2022?
I have.
Have you seen other video footage and evidence about that taillight since January 29, 2022?
I have.
Have you seen other information since you last testified last summer about the taillight?
I have.
And seeing this extraneous
So this is another good line of questioning. You've seen all this other stuff. Could that have affected your testimony? And again, Barros could have said no, right? But he doesn't. He's honest. He says yes. And I think this is a pretty good attack on his credibility. Amy, this is why I try to hit every single one of those every time I do opening or closing. Different demonstrative aids to try to hit every different kind of learner. Brian B., this warms my heart. Said Barros is like a Grease 2 soundtrack, nearly perfect.
information, other information. Do you think that played a part in some of your difficult memory?
Objection.
I'm going to allow that.
Your Honor, give me approach.
RS, I did not see this. After court, Karen explained why Barros agreed with Brennan on the last Recross question. Can we see it? Hope the jurors understood. I'll have to look at that after. I'm going to skip this side.
You've seen quite a bit of information about this case and the issue regarding the taillight since you first made the observations back in 2022. Wouldn't that be fair to say?
Would be fair to say.
And based on all the additional information you've read and seen, would you agree it's had some effect on your memory?
I guess.
Well, I don't want you to guess. You testified that you made explanations at the last trial that you didn't make, right?
Correct.
You had a memory as you testified in representation on the road and you tried your best about things that just didn't happen, right?
Right.
Would you agree that you have some difficulty with your memory?
I'd agree.
I want to show you some evidence of that taillight.
Yeah, that's tough. That's tough. But good job by Hank Brennan to get all that out. He also says he's seen the traversement video too many times to count. Brennan gets him to agree there was a lot of snow on the taillight. Could have impeded his view of the damage. And then we'll get to kind of the last picture he shows him.
Is that consistent with the damage that you saw when you looked at that Lexus in Dayton hours later?
Consistent.
I agree, Greg. He may have been a little shocked, like, crap, I screwed up. I don't want to get impeached again. But Brennan just getting him to agree with these consistencies, we know how Brennan's going to use it.
Later.
Consistent.
Can we go to Exhibit 10, please? And before you show it, I have a couple questions. This was a snowstorm, kind of like a Dayton. And it's a far view, so I don't want you to guess. If you're not sure, you can tell me.
I wouldn't be able to tell you. I can't.
Exhibit 11, please. Can you take a look to the right? See that right tail light, the white part?
I can.
Missing. Yes?
Looks like snow is packed on it.
Does it look like there's a red tail light there?
Does not.
This is before you saw the car in Dayton. Do you know that, or you wouldn't know that?
That doesn't look like the Reed's driveway.
Do you know if this photograph was taken before or after you made your observations in Dayton?
I do not.
The right rear tail light and the missing parts of it, is that consistent with what you saw around 3:27 on January 29, 2022?
Yes.
Have no further questions.
And that's the end of his cross. I thought it was really good. You guys tell me in the chat, do you think he not completely discredited him and makes you say, like, everything he said is a lie? Do you think Hank Brennan will make at least some jurors question Barros's credibility? Yes or no? Did Hank Brennan make some people question his credibility? Shout out to John O'Rourke. Just good, respectful debate. Nothing but respect for him and all those who are respectful in debate. I echo this. John O'Rourke, there's a bunch. There's a bunch of people in here that can respectfully disagree. I love it. I appreciate it. I don't want this to be an echo chamber. I want to be able to see it from different ways.
Do you remember the conversations that you had?
I do.
Do you remember the phone calls that you received?
I do.
The first one?
This is him talking about what he actually remembers about that night. It started off a little rocky. He's like, is your memory bad? And Baros is like, I guess, yes, it is bad. Something like that. But eventually when they get to the night, it gets a little better. It was a good redirect overall.
Do you remember the time?
I do.
Do you remember the weather?
I do.
Do you remember who you met there?
I do.
Do you remember the conversations that you had?
I do.
Do you remember the phone calls that you received?
I do.
The first one?
I do.
The second one?
I do.
Do you remember being in the garage and speaking with someone?
I do.
You remember this lady, pretty lady right here in blue?
I do.
You remember meeting Mr. Reed?
Briefly.
Handsome gentleman with a gold tie?
I do.
You remember all that?
Mhm.
Do you remember the SUV?
I do.
Do you remember the condition of the taillight?
I do.
You were asked whether or not you saw Trooper Proctor in any way manipulate that right rear taillight while it was out at Dayton, while you were there, correct?
Correct.
You said no. Honestly, I never saw him touch it, right?
Correct.
Were you in the Sally Port in Canton PD? Sorry, in Canton, in the Sally Port at the police station
I wasn't.
at 5:30 p.m.?
Objection.
Sustained.
At any point, did you ever go to the Sally Port at Canton PD that day?
All these objections are sustained, so I'm going to just jump ahead a little bit.
By the way, you and I did meet once before, correct?
Correct.
Was that before or after you testified last year at another hearing?
After.
And you were called by whom last year at the other hearing? The defense or the Commonwealth?
The Commonwealth.
You testified for them?
Correct.
Objection, move to strike.
So that's stricken. It's beyond the scope.
Did the Commonwealth ever contact you after your testimony at the hearing last year?
They did not.
Did they ever call you on the telephone?
After?
Correct.
No.
Did they ever send you a subpoena?
No.
And you testified last.
I mean, especially with this missing witness instruction, which we'll have to talk about on another video. I don't have time today. This is another huge piece of evidence because this is all in evidence that they called in the first trial. This is what he said. That's not what it looks like. Absolutely not. And they've never spoken to him again. They are trying to hide evidence from you. Sometimes that's not appropriate argument. I think it's perfect for this case. Show the tow truck. It shows the taillight intact in red. I believe you. I don't have the timestamp on here. I just don't have time to go back to it. We will try to do it, Bo, on another video. Remind me, send me a timestamp. I will try to do it.
Last year, that the taillight was cracked, or damaged, but not completely broken, correct?
Sustained.
You and I met in a hotel in a conference room, correct?
Correct.
Anything sketchy or nefarious about that?
No.
Did I introduce myself to you?
You did.
You happen to know I live in Los Angeles?
Correct.
I don't have a house, right?
Correct.
I don't have an office out here, correct?
Objection.
Sustained.
Yeah, Jackson's like, it's not that weird, right? Then Brennan again on Recross. To me, pretty strong ending here. Let's take a listen to how he ended today. Last thing the jury felt. Then I'm going to answer some questions and I got to run. But to me, overall, I thought Barros was amazing witness for the defense. I think some jurors are going to absolutely be entrenched in a not guilty camp at this point. But that being said, Brennan did as good of a cross as you can to hope some jurors are like, well, can we really trust what he's saying? Now, the problem is even what he said the first trial was bad for them too, right? It was bad for the Commonwealth too.
Condition of that taillight.
I do.
Is the condition of that taillight the same as the photo that I showed you on my direct examination? No. Okay, that's all.
All right, here comes Brennan now.
You would agree that your memory has changed since last time you testified in this courthouse?
Yes.
In the photo I showed you, the close-up with the missing right rear taillight, is that consistent with your memory of what you saw in Dayton on January 29, 2022?
Objection.
I'm going to allow it. It's opened
That's
up.
not evidence.
It was opened up.
Is it consistent with
He also was not specific enough with what picture he's talking about to me. He should have had to show him the picture again, but
what you saw on January 29, 2022?
It is.
Thank you.
All right, Sergeant, you are all set.
Thank you.
so C Squad said, I was confused at the end because it seemed like Baros was confirming Kara's taillight was the same at One Meadows at the Sally Port. It was the way Hank Brennan asked the picture or the question about the picture. Was this similar to the close-up? Like which picture you're talking about? It couldn't have been the one at the Sally Port. Did you see the clip of Yannetti and Alessi heading out of court? Somebody yelled, "Love you, David," and Alessi mutters, "Everyone loves Yannetti." No, I did not see that. I did not see that. CJ, sorry, Peter. Who is Easter again? He's the investigation expert that the defense wants to call to talk about how bad this investigation is. Looked at merch and want a couple things you don't have in stock, 500K all the way. Got to talk to John on that. Got to talk to John. I'm not the guy with that. Barbara, I think the picture memory was sleazy. Is this normal for them to do? And could it have been objected to by the defense? So sometimes things can get tricky. But if you say something you know is wrong, like this picture was taken before you guys took the car, or this was taken before this, or this was taken after that, and it's just factually wrong, it's problematic for a lawyer. Is there also a tow truck driver who said it was just a small break? I'm not sure. All of Hank Brennan's witnesses' memory get better with time. He's literally discrediting his own witnesses' testimonies. He did that in more ways than one with this witness. Why doesn't the defense say ask and answered when Brennan always asks this question over and over again? Maybe they like the answer. I don't know. I felt myself saying the same thing. That's already been asked and answered. Laura, I see a second mistrial. Would the state try a third time? I think the answer would be yes, if I had to guess. Can the defense appeal right now about the rejected motions? No, not that one. I mean, during the trial itself. And what if the higher court ruled an instant dismissal? It's not going to happen. It's not going to happen. Normal to take so many half days and days off. On a long trial, it's really not that abnormal. I feel like last trial was much worse than this one because there was a holiday mixed in. Why would a cop who was involved in this case for 1 hour write a detailed report on the damage? Asked Ms. Dever. He couldn't know his observations would be this important. I think he did fine. I think what he should have just said is, yeah, I was more detailed this time. I don't remember specifically. I didn't read my testimony. Let me read it. I'm pretty sure I did this, but maybe I'm wrong. He could have been a little more like nonchalant about it, as opposed to just kind of admitting his memory sucked, which I feel like he did a little too easily. If any juror doesn't trust Barros, how could they possibly trust the Commonwealth cops? Good point. At the end of the day, who is more likely to be honest? Well, the Commonwealth cop said what I think Barros should have kind of pushed back a little bit, that no, my memory is good. Why does Hank Brennan keep saying Alisi? I don't know. Being on the stand has got to be nerve-wracking, almost like being interrogated. Absolutely. Barros being honest, not reluctant, aka Dever. I agree. I think he did a good job. I really do. Sergeant Barros was hit by a drunk driver in 2023. Wish that would have come out. That could affect his memory. It's not relevant to this case, though. Actually, might have been good for the Commonwealth to bring that out, but they probably don't want to garner sympathy with the jury. Charlie, we did it. My chant last summer was 500 mil. Yes, we will. That's awesome. P. Price, thanks for the super chat. All right, that's all I got. I got to go. I got to run. You guys are the best. Hit that like button. Until tomorrow, half day in court, but full video here. Peace out. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.